My client was an insurance company that insured a gentleman who had purchased a luxury RV. But the person purchased this RV under very suspicious circumstances. He bought this RV for hundreds of thousands of dollars less than what its fair market value was, and it was nearly new. He bought it off the side of a road by a gentleman who said he was selling it for a friend. He never met the person that actually appeared on the title before he purchased this RV. So 30 days later, the FBI comes knocking on my client's insured's door and confiscates the RV as a stolen RV. The insured turns around and makes a claim under his policy for the full value of this luxury RV, which would have represented a windfall to him. My client, understandably, had some resistance to paying that claim, but they couldn't quite figure out how to put this factual scenario into the policy language, how the policy language interacts with this fundamental concern they had that this person had purchased a stolen RV under suspicious circumstances and then was seeking to recover the full value of the RV. So that caused us, when we were retained to represent my client, to do some digging. And we realized that the appropriate category to put this case in is based on this fundamental concept in insurance law called the insurable interest. And what the insurable interest doctrine is that people need to have a sufficient interest in a piece of property or in somebody else's life for it to be insured and for it to not be a wagering contract. You can't go out and buy a life insurance policy on a stranger and then hope to recover under that policy, essentially betting on whether that person will pass away during the policy period. So this insurable interest is a doctrine that makes sure that people have that appropriate interest in a piece of property. And what it says is that you can only recover under a policy to the extent of your insurable interest. Well, in doing some research, we realized, although it hadn't received much treatment under Florida law, the state of the law, the best as we understood the state of the law, was that if you acquire a piece of stolen property, your insurable interest in that property is only a possessory interest. You have an interest against other parties for the rightful possession of it, except for its rightful owner. And it's much different than the insurable interest you would have in something you own that wasn't stolen. At trial, because the insured was seeking to recover the full value of the stolen RV, they didn't put forth any evidence with respect to loss of use or being without their possessory interest. And based on our argument on the insurable interest concept, we said, if anything, their recovery had to be limited by the interest that they possessed, which was a possessory interest, and were able to persuade a jury that they weren't entitled to the full value of the RV. And after a week and a few days trial, the jury came back with a verdict in favor of our client.